Tonight, we witness a courtroom confrontation that is raw, direct, and utterly unflinching. Meet Tony S.K., a young woman facing the consequences of a crime that's as dangerous as it is deceptive. The charge, robbery. But the method is what's truly chilling. The prosecution alleges she lured a victim using text messages promising sex, only to set them up for a violent robbery. She's accepted a plea deal for a lesser charge, hoping for leniency. But she's about to face a judge who has read every single line of the case file and has zero patience for games. Judge Boyd is about to dissect the defendant's life, excuse by excuse, lie by lie. What follows is a masterclass in judicial accountability, where a string of well-rehearsed stories about bullying, illness, and bad luck collides with the cold, hard reality of the law. Get ready, because the judge is about to ask a question that will change the entire tone of this hearing.
Court is going to call 2019 CR 11417D, State of Texas versus Tony Renee Schiaretti. I have parties announced for the record for the state.
Ryan Groomer for the state of Texas.
For the defense. I'm sorry, I have to turn on the fan. It is so hot in here. And are you Tony Schiaretti?
Yes, ma'am.
Ms. Schiaretti, I'm going to show you what's entitled Court Admonishments and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand the state is proceeding on the lesser included offense of robbery? That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your
Did you
Honor.
understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court to find you guilty, not grant you community supervision, and sentence you up to 20 years in prison and up to a $10,000 fine? Did you understand?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
She has.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. Showing you the plea bargain page. Did you review that page with your attorney and did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of robbery. There's a $1,500 fine. State recommends deferred adjudication. Did you understand that to be the plea bargain agreement?
Yes, Your Honor.
Defense is at the plea bargain agreement.
It is. Your Honor.
State is at the plea bargain agreement.
It is.
Next,
Judge.
I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 5 years. There'll be a TAP evaluation, community service hours, no contact with the following persons: Kerry, Kerry, Yadel, Yelldel, Terrence Smith, Michaela, Makayla, Guerra, Ezekiel Washington, Arthur Wallace, that's AURTHUR, and you are enrolled and obtain a GED and maintain employment. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the lesser included offense of robbery, how do you plead? Guilty, not guilty, or no contest?
No contest.
State any evidence to support the defendant's plea.
Yes, Judge. State would offer state's exhibit number 1 to the court. No.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence state's exhibits 1 and attachments and will do the same.
And there it is. The first and most critical test of accountability. The judge cuts straight to the core of the crime, asking what she's doing with her life besides allegedly setting people up to be robbed. The defendant's immediate response is a classic deflection. Those text messages weren't actually me. She claims her phone was taken by her much larger co-defendants, painting herself as a small, helpless bystander who had no control. This is a high-risk, high-reward strategy. If the judge believes her, it could soften the sentence. If she doesn't, it destroys her credibility from the very beginning. The defendant is essentially pleading guilty while simultaneously pleading not guilty to the most damning details. She's trying to have it both ways, but the judge's expression tells us everything. She's not buying a single word of it, and she's about to re-engage with blistering intensity.
All right, after viewing state's exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty.
This is where Judge Boyd takes off the gloves. She just called out the defendant's entire story as a work of fiction. Don't come in here playing as though, oh my gosh, I didn't know anything. The judge makes it crystal clear she has read the evidence and knows the defendant was an active participant. By repeating the question, other than luring people over, what are you doing with your life? She is refusing to let the defendant change the subject or play the victim. This is a powerful judicial technique. She's forcing the defendant to confront the reality of her plea, not the sanitized version she wants to present. The defendant's narrative has completely crumbled. Now, stripped of her initial excuse, she has to answer for her actions, and the conversation pivots from the crime itself to the series of life choices that led her here.
To have the court with deferred finding of guilt should apply for deferred adjudication. Anything you want to say on behalf of your client?
Judge, just that we'd ask the court file a plea bargain, and if the court pleases, we can waive a PSI this time.
So Ms. Schiaretti, what are you doing with your life other than inviting people under the pretext of having sex with them and then having them robbed? What are you doing with your life?
Those text messages weren't actually me. They had taken my phone and they're all 6'1" and I'm 5'1" and I couldn't jump up and grab it. I wasn't near my phone.
So do
But
you want a jury trial? Because see, right now, what is happening is sometimes people don't think that I've read things because I read quickly. So here's the thing. You are involved with all of these defendants. So don't come in here playing as though, oh my gosh, what? I didn't know anything. Somebody took my phone and started sending these text messages and these people just came over and then a robbery just happened. And I'm just here not knowing anything that's going on. So let's be honest, because you've already entered a plea to this. So other than luring people over with text messages for sex and then having them robbed, what are you doing with your life?
I want to get a GED, go to college.
Why do you need a GED? Why do you complete school?
Because I was getting bullied my sophomore year, moved away for a year to go to school.
Did you go
And
to
then I
school
had
while
to
you
move
were
back
away?
here. Yes. My junior year, I spent it in Illinois. Then I moved back here and I didn't go back to school because I didn't want to go through what I went through my sophomore year. And
So you just came back here and did nothing?
I was gonna go to a different school, but my mom couldn't take me to and from at the time because she had work.
What is the
And I
via
was
bus
going
for?
to,
Why, see, this is the problem with society today. Everybody wants to have their own vehicle and drive to where they get to. We used to walk to school. Or guess what? You take the via bus. So if your mom can drop you off at school, you're old enough to get involved with the people in this to rob some people. So why can you take the via bus to get?
Let's recap the waterfall of excuses we've just heard. She couldn't finish school because of bullying. She moved away, but then came back and didn't re-enroll because her mom couldn't drive her. She couldn't take the bus because, well, there was no reason given. She lost her job because she got sick twice, and her manager just didn't like that. In her narrative, nothing is ever her fault. She is simply a victim of circumstance, bad luck, and mean people. The judge has patiently listened to this entire litany of rationalizations, but her patience is clearly wearing thin. She's about to pivot from the defendant's past failures to her present habits with a question that every defendant on probation dreads. She's asking for a drug test and she's demanding the truth right now before the results come in. The trap has been set.
To school. Because right now, all I'm hearing from you are excuses. I couldn't go to school because I was bullied. So then I went to Illinois. And who did you go to Illinois with?
I was staying with my cousin.
All right, so there's a reason why you got sent back to San.
I just hit it once. This is one of the most common and least believable claims judges hear regarding drug use. After admitting her test will likely be positive for marijuana, the defendant immediately minimizes it. The one-hit claim is an attempt to frame the use as a rare, isolated mistake rather than a regular habit, especially while she's unemployed and living with her mother. But to a seasoned judge, this excuse is a massive red flag. It signals that the defendant is still not being fully transparent and is trying to manage the consequences instead of taking full ownership. The judge's skeptical tone says it all. She knows that where there's one hit, there's often more. This admission, coupled with her history of excuses, is cementing the judge's decision to impose incredibly strict conditions.
Antonio from Illinois. If things were going great in Illinois, you would have been in Illinois and you would complete it, whatever you needed to complete it. What I've discovered in my time as a defense attorney and a prosecutor involved in CPS cases, when sometimes, and I would say about 60% of the time, when children leave their home to go live with their cousins in Illinois, one or two things are happening. Either the parents can no longer control them and they say, well, let's try a new setting. Now, I can't afford to go to Illinois, so I'm going to send you to Illinois with friends and family. Or either there's something wrong with the parents and they're like, I'm going to do my own thing. I don't want to be a parent, so I'm sending you to Illinois. Obviously, there was something happening in your home life where either you were not doing what you were supposed to do, which is attend school, and they sent you to Illinois for a change of scenery. Things were okay there for a while, but then something happened there. Either you were not doing what you were supposed to be doing, and they said, look, not our problem because not our child, we're sending her back to you to San Antonio. So all I've been hearing from you is what you're gonna do. But what have you been doing since this offense?
I was working, I had my own apartment, I,
Was working. Why are you not working?
because I got sick and I had to get out of work for 2 weeks and then I got sick again and my manager just didn't like that I got sick and I was out of work for 2 weeks.
So who are you living with?
Right now I'm living with my mom.
And what problems are you causing there?
No problems.
So are you seeking another job?
Yes, I'm currently looking for another job. I'm going to apply at Amazon with my aunt and see how that goes. My aunt really likes it, so I feel like I'll like it. There's a couple other places that I have in mind.
And if you're drug tested today, what are the results going to be? And know that you are getting drug tested today. So if it's going to be positive or something, it would behoove you to tell me right now what it is. Yes, tell the truth and shame the devil. What will it be?
It might come out positive.
For
just
what?
for marijuana.
Who you've been using marijuana with? Because I'm hoping it hasn't been at your mom's home.
No, it's not.
So who have you been using marijuana with?
One of my friends had it and they asked me if I wanted it. I hit it once.
No, nobody hits marijuana once.
No, I did. I swear. I just hit it once.
So you're out of work, but you do find time to have marijuana with friends. So that means that you are going to end up causing problems with your mom. I'm going to try to stop that and nip that in the bud. So how far did you go in school?
Senior year. That's when I didn't go.
Do you have any children?
No.
All right, any other questions from either side?
Nothing from the state, Your Honor.
Nothing, Judge.
All right, and you're going to be drug tested today. And so you're telling me it's only going to be marijuana?
Yes, ma'am.
All right, I'm going to sentence.
With the sentence delivered, the judge gives one final chilling reality check. 5 years of deferred adjudication, a hefty fine, 200 hours of community service, a strict curfew, and constant drug testing. But it's her closing words that hit the hardest. The judge lays out the two brutal possibilities of what could have happened. The victim could have been killed, leading to a capital murder charge, or the defendant herself could have been killed in the botched robbery. This isn't just a sentence, it's a lesson in cause and effect. The judge forces her to confront the life or death stakes of her actions, something the defendant has avoided throughout the entire hearing. She's leaving the courtroom not with a slap on the wrist, but with the weight of a 5-year probation and the stark reminder of how close she came to a far more tragic outcome.
To 5 years deferred adjudication. There's a $1,500 fine. Time and money are going to run concurrent.
And now we fast forward. The defendant, Tony S.K., is back in the same courtroom in front of the same judge. This is the moment of truth for anyone on probation. The first hearing was about setting the rules. This one is about whether she followed them. We've already seen her knack for storytelling and her reluctance to take full responsibility. The critical question now is, has anything changed? Has she complied with the strict conditions Judge Boyd set for her, or did the excuses and bad habits continue? The judge starts with a simple, "What's going on with you?" But we know this is an interrogation. She is about to be confronted with reports from her probation officer, and as we'll soon see, her version of events is about to be challenged once again.
There's going to be a UA, and I want her to be continually tested for levels, Ms. Reyes, and she's going to do a UA today.
Yes, ma'am.
And if she tests positive for anything other than marijuana, I want to know.
Notice the pattern here? Once again, the defendant crafts a detailed story where she is the innocent victim. This time, it's a dramatic altercation with a roommate who allegedly stole over $6,000 from her, forcing her to call the police and move back home. She makes sure to mention her restraint, telling the officers, "I'm on permission, I can't get physical." She is preemptively building a defense, portraying herself as responsible and level-headed in a crisis. It's a compelling story, but the judge is about to ignore it completely. Instead of discussing the roommate drama, the judge goes straight for the official record, a positive drug test for marijuana from March. All of the defendant's storytelling is instantly irrelevant. She can't talk her way out of a lab result.
I want her back in court. There's going to be 200 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the COVID vaccination, but if you do, 40 of those hours will be waived. You're going to obtain your GED, full-time employment. And for the court, full-time employment is at least 8 hours a day. So if you need to get 2 part-time jobs and get your 8 hours, then that's what you're going to have to do. There's to be no employment as a home health care provider or with minors. There's to be regular reporting by Zoom or in person. So if you can't report by Zoom, you're gonna have to report in person. I'm gonna want her to have a curfew. So you need to be in the house by 6 p.m. The only exceptions to being in the house by 6 p.m. is if you're at work. And she's only allowed to leave the house by 7 a.m. So 7 a.m. to 6 p.m. I'm going to want field visits, random, 3 times per month. She's to reside with Janetta Chiretti. Rebecca, is there anything else that she needs? Is there any restitution involved here?
I don't believe so, Judge.
All right, anything else she needs, Norma? I'm sorry, Rebecca.
No, Judge, but on the employment, you want her to have the employment within how many days?
Within 30 days.
Okay, that was it, Judge.
Thank you. Is there anything else you need from me in order to be successful?
No.
Judge, in regard to the curfew, the Amazon job she's talking about is a warehouse in San Marcos. There may be some problem with getting there and back as far as the curfew goes.
It's overnight as well. Because it's.
The only exception to your curfew is if you're at work.
Okay,
So you'll need to provide proof of that.
okay.
All right, we can go off the record. I don't know if you realize how dangerous what you did was. Number one, somebody could have been killed.
This is the most stunning moment of the hearing. The drug test came back with faint lines for cocaine. This is a catastrophic violation, but watch the defendant's immediate reaction. Does she take responsibility? No. She instantly deflects, bringing up her brother's addiction. My brother is an addict with that. I would never do it. It's an astonishing pivot. In one sentence, she attempts to evoke sympathy, deny culpability, and indirectly blame her brother for her suspicious test result. The judge, however, is having none of it. She immediately cuts off that line of defense and issues a direct order. She is forbidden from going to her brother's or his girlfriend's apartment. The judge identifies the potential excuse and surgically removes it from the equation. It's a swift, decisive move to eliminate any future blame shifting.
In which case, we'd be here for something different, maybe capital murder, who knows? Number two, when you send text messages to people, telling them or offering them sex, and they come over and expecting that, and it doesn't happen, but instead there's a robbery that's taking place, you know what could have happened then? Somebody could have killed you. And you know what everybody would have said? Oh, well, she came over here to rob somebody and she ends up getting killed. Your parents, I don't know your mom personally, but obviously she's trying to do something with you and help you with your life. You're making your life more difficult than it has to be. I always tell people, life is so simple. If you follow the rules, it will be fine. Now you've made your life exceptionally hard because this deferred adjudication is going to follow you around. Do you understand? All right, good luck to you.
And so after all the stories, the deflections, and the dramatic denials, the defendant leaves the courtroom on an even shorter leash. Her curfew is back in full force. She's banned from visiting her brother, and her employment will be scrutinized with pay stubs, not just screenshots. The faint lines on her drug test, combined with her history of excuses, have erased any trust she may have hoped to build. Judge Boyd's final instructions are a masterclass in control, designed to leave zero room for interpretation or manipulation. The defendant is now under a microscope, with every action monitored. The question remains, is this the rock bottom that will finally force a change, or is it just a matter of time before she's back in this courtroom again? What do you think? Let us know in the comments and subscribe for more in-depth courtroom analysis.
All right, what's going on with you? What's going on in your life?
I just started a new job.
Right.
Um,
Doing what?
I'm a server.
All right. And if you drug tested today, what are the results going to be?
It would come back negative.
All right, we're going to do a drug test, okay?
Okay, I did one yesterday.
Okay.
Okay.
All right, so we're going to do a drug test. And then who is your brother's girlfriend?
Kaylee.
All right.
I don't know her last name.
So do you still live with your mom?
Yeah, I just had to move back in there,
All right.
like
So
in April.
you're saying you had to move back in?
Yeah, I had my own apartment and I had it with a roommate. And I was giving her 800 a month and been friends with her since freshman year, found out she wasn't, all the bills, all the money I gave her a month never went towards a bill. So we were over 6 grand in her rent. And I had all the receipts on me paying her and everything, so they let me out of the lease early. And it was a big altercation. I had to call the cops because she got physical with me and I didn't. I told the cops, I was like, I'm on probation. I'm not gonna get physical with her and risk getting in trouble for that. It's not worth it.
All right, you're going to do a UA today.
Okay.
And I know previously there was an issue with you, and this is from March 2024, where you returned back positive for marijuana and they did progressive sanctions. So we're going to do a UA, and then we're going to tighten up your schedule with your curfew for being at home with your mother.
Okay.
So first thing, we're going to see what this UA, the results are.
Mhm.
And then we're going to come back and I'm going to give you instructions, but your curfew is going to get tightened up. Okay.
Thank you.
All right. Thank you. Okay. All right, Miss Schiaretti, come forward. All right, you're gonna go back on your curfew. So she needs to be at her mom's home by 6 p.m. unless she's at work. Yes. All right, excuse me, everyone. Okay. Yellow, very loud. That's okay.
I saw that there was an SR sent that she would continue with the curfew, but all the other ones that I saw were like for travel and for rent.
I think there was a miscommunication probably around August. So you're going to be on curfew. You're going to need to be in your house by 6 p.m. every day, unless you are at work. Do you understand? If you're not at your house at 6 p.m., what's going to end up happening is they're going to give me notification and a motion to revoke could be filed. You understand? So what is your work schedule?
I know this week, today's my last day off, or Wednesday, Thursday, we might close that one. I'm not 100% sure on like the times yet. I'm still gonna need.
All right.
This is like my first week.
You are going to send your work schedule to probation, and you're going to give that to your probation officer. If you are not at work, you need to be in your house by 6 p.m. Do you understand? If you're not in your house by 6 p.m., they will know and they're going to let me know. Do you understand? And they're telling me that you're testing some of those lines were faint. Their count is negative, but there were some faint lines for cocaine. So I don't know what's happening with you, but
I confirmed my brother, in all honesty, my brother is an addict with that, and I see the way he is with it, I would never do it. I just see the way it breaks my heart to see.
All right, so here's the thing. You're not allowed to go to your brother's apartment, your brother's girlfriend's apartment. Do you understand? If you are going to visit with your brother, it is to be by phone only or at your mother's house. Do you understand? Okay. All right. And you're not allowed to go to his girlfriend because it says here that you were at your brother's girlfriend's apartment complex at one point in time swimming.
Not her.
All right, you're not allowed to go to your brother's girlfriend's apartment complex. Do you understand? And you shouldn't be anywhere but in your house by 6 p.m. unless you're at work. Do you understand? And if we could continue with field visits.
And Judge, one thing I would suggest, I was reviewing her proof that she provided to Officer Parker.
Mhm.
And they're mostly like screenshots of her schedule. I
Mhm.
would also, it doesn't say anything like her name.
Mhm.
It's just kind of the schedule. I would suggest making sure you're turning in your paycheck stuff. And if you get like direct deposit or something, just something that shows like you're working. And
I just haven't gotten that yet.
No,
Because
no,
like
fine.
I'm still kind of, I haven't gotten a paycheck from there yet, because it's mainly just in the, every 2 weeks we get a paycheck. I want to say it's like.
Yeah, and I would say, because it's just screenshots, I would suggest.
I'll make
you're
sure.
Turning in like your actual like proof that you're getting paid. If that is part of it, yes, you can
Yeah.
screenshot from the apps, and I know a lot of employers use the app these days. But just something that shows like a good.
Yeah.
All right, so you understand what's expected? All right, make sure you follow through. If there are any issues, you can always come back to the court, okay? All right, good luck.